morning to everybody in and around the courtroom. May we please have appearances for the day, starting with the prosecution.
Yes, good morning, Your Honors. Good morning, counsel. Good morning, everyone in the courtroom. Mark Harmon, April Carter, Rona McKenna, Barney Thomas, Rafael La Cruz, and Carmela Javier for the prosecution.
Thank you so much for the defense.
Good morning, Your Honors. Good morning to all the participants in the proceedings. General Perišić is represented in court today, as in yesterday. Novak Lukic, Gregor Highsmith, Ted Mayer, Tina Drolitz, Tina Montgomery, and Boris Zorko.
Thank you very much, Mr. Lukic. Madam Carter.
May it please the Court. I will address the third prong of Perisić's 7-1 responsibility, specifically the provision of men from the VJ Special Unit Corps to participate in the Panjshir operation to take Mount Zuch. The defense has argued in paragraph 814 of its final trial brief that no unlawful acts have been alleged in conjunction with the Panjshir operation to take Mount Zuch, and more specifically, that there is no nexus between the Mount Zuch operation and the scheduled incidents. It's the prosecution's submission that the defense fundamentally misunderstands the crimes of which Mr. Perišić is charged. The indictment lays out in paragraphs 40 through 46 that the underlying crime base is a protracted campaign of shelling and sniping upon Sarajevo, resulting in the killing and wounding of thousands of citizens. One must look at the scheduled incidents as representative of this campaign. I'd like to first turn to the campaign itself. The campaign against Sarajevo began in May of 1992. By 30th of May of 1992, Slobodan Milosevic had already declared the bombardment of Sarajevo to be bloody and criminal, for which there was no justification. 30th Personnel Center members Ratko Mladic, Stanislav Galic, Dragomir Milosevic, and for a brief period, Cheta Sladoje orchestrated and executed this campaign. Martin Bell described this siege. He indicated, "It was a little bit as if the Great War was being refought in a modern urban environment. No one was spared from VRS sniper and artillery. This was Russian roulette on a grand scale." In his final trial brief, even Perišić himself does not dispute that civilians were targeted in Sarajevo. This can be found in the defense final trial brief at paragraph 554. The first scheduled victims were a mother and their child who were struck by a VRS sniper bullet while walking down the street on September 3rd, 1993. This is scheduled incident B1. Following Perisić's promotion to the Chief of General Staff in August of 1993, fire intensified over the winter. If we can now briefly move into private session.
May the chairman please move into private session.
Could we ask the speaker to slow down or to provide
Best, Your Honor.
We're in open session, yes.
Thank you very much, Mr. Rogersville.
During the winter of 1993, 2 sniping and 3 shelling incidents occurred during these months. The first, a man working to clear rubbish was shot on 2 November 1993. And that's scheduled incident B2. A woman was shot while riding her bicycle on 6 January 1994, scheduled incident B3. 6 children were playing when a VRS shell fell upon them, killing all 6 and injuring 3 more. 8 more people were killed and 18 were injured when shells fell on a Dobrinja residential area on 4 February 1994. Finally, the Macaulay Market was struck on 5 February, killing 60 and injuring over 140 more, scheduled incident A3. As will be described further The Panjshir operation to take Mount Zuch, in which Perišić deployed VJ Special Unit Corps members, also took place between December 1993 and February 1994. However, even during non-peak periods, civilians were not safe. Scheduled incidents B4, B5, and B6 took place in the summer of 1994, where 3 adults and a child were sniped in a tram on 19 June 1994. 2 teenage girls were shot while walking down the street on 26 June 1994. And a 13-year-old boy window shopping was struck by a sniper's bullet on 26 June 1994. If we can please move into private session.
May the chamber please move into private session.
I'm sorry.
We're back in open session, Your Honor. Thank you.
Thank you so much. Yes, now you may proceed, Madam Carter.
Thank you, Your Honor. The Basharsha market was shelled during this peak, killing 2 and injuring 7 on 22 December 1994. Havisa Perišić and Sabina Sabanic were sniped on a tram on 23 November 1994. The court may remember in Mr. Harmon's opening remarks that Ms. Perišić still bears the wounds that she suffered on that fateful day. A woman was shot gathering firewood in her own backyard on 1 December 1994, and 3 more people were sniped on a tram on 27 February 1995. If we can move into private session.
May the chamber please move into private session.
We're back in open session, Your Honor. Thank you.
Thank you very much, Mr. Registrar. Yes, Madam Carter.
2 more people were sniped on a tram on 3 March of 1995. This spring also saw the introduction of air bombs against Sarajevo, although even the defense expert Jokic acknowledged it to be totally inappropriate and wrong to use air bombs in an urban environment. Nonetheless, 2 air bombs were launched on 24 May 1995 alone, killing 2 and injuring 7 in scheduled incidents A5 and A6. In response to this firing and aggression, the UN Rapid Response Forces were deployed in June of 1995. This month was particularly dangerous due to VRS firing 150 artillery and mortar rounds per day, as described by witness Per Anton Brenskag. This included the firing on the Water Distribution Center, killing 7 and injuring 12 on 1 July 1995. The summer culminated with the killing of 35 persons and the injury of 78 more at the Makali Market on 28 August 1995. The VRS continued this campaign against Sarajevo until 21 November 1995. The scheduled incidents give detail to 405 of the thousands of victims subject to the siege. Perišić served as VJ Chief of General Staff for 26 months of the siege. Turning now to the Mount Zuch operation that occurred in the context of the siege. The Mount Zuch operation and Perišić's assistance to it detailed at paragraphs 483 to 502 in the prosecution's final trial brief. Perišić met with Slobodan Milosevic, Ratko Mladic, Radovan Karadzic, and Momčilo Perišić and others on 13 December of 1993. At that meeting, Karadzic identified the strategic objectives of the Bosnian Serbs, one of which was to partition Sarajevo. Karadzic emphasized that Sarajevo is a priority and a key to the war. He went on to say that in Sarajevo, we have to capture some elevation points that will ensure our drive. Finally, he indicated that Zuch is especially important. On 14 December 1993, Perišić and Mladić met twice. In the first meeting, Perišić committed weapons. In the second meeting, he committed to providing about 100 professionals by 20 December 1993 onto the disposal of the SRK and equipped for combat. On 14 December 1993, Mladić also issued a supplement to his Directive 6, which stated that in addition to SRK, VJ Special Forces, up to 120 men, would carry on an attack along the Vagosha, Zuch, and Povolichi axes. The VJ Special Forces were men from the 72nd Special Brigade, the Guards Brigade, the 63rd Parachute Brigade, and the Armored Brigade. Each of these brigades formed part of the VJ Special Unit Corps that were directly subordinated to Mr. Perišić. Readiness for the attack was to take place on 19 December. However, prior to that, on the 15th, Perišić directly met with members of the 72nd Special Brigade and ordered them to deploy and to take part in the VRS offensive operation against Zuch. When the men from the 72nd Brigade arrived, 30th Personnel Center member Galich briefed them on the upcoming actions. He told them if Zuch was taken, all of Sarajevo would be under SRK control. A similar sentiment was given by Perišić when he spoke with the men of the 72nd, where he indicated that Zuch was a strategic location and needed to be controlled by Bosnian Serb forces. If we can now move into private session.
May the chamber please move into private session.
We're back in open session, Your Honors.
Thank you so much. You may proceed.
In excess of the numbers described in the supplement to Directive 6, by 31 December 1993, approximately 200 members of the Guards Brigade alone had deployed to the front line. While there, the Guards Brigade engaged in offensive and defensive combat operations and trained snipers. On 7 January 1994, the UN Security Council President condemned the actions in Sarajevo, particularly condemning the continuing military pressure and relentless bombardment by the Bosnian Serb forces. This can be found at Exhibit P2475. As described in the annexes to the Commission of Experts report admitted as P1535 at page 36, from 4 to 7 January alone, Sarajevo was struck by 3,915 shells. As an aside, the defense claims in paragraph 520 of its final trial brief that the prosecution has not stated the purpose for the Commission of Experts report. The trial chamber admitted both P1112, the Commission of Expert report, as it was published in installments in the newspaper Borba, and P1535, the annexes to the report without restriction in its decision of 21 December 2009 relating to MFI documents. P1536, the report in its official form, was limited to notice at transcript page 7382, lines 2 through 6. Moving back to the facts of the Zuch campaign. The day after the condemnation by the UN Security Council President, Perišić arrived in Vagoshka and met with VJ and VRS commanders, as well as RS politicians. 30th personnel members Mladić and Galich were present, along with the head of the VJ Special Unit Corps. These corps, the men part of the corps, would not pull out until 27 to 30 January 1994. As seen by placing the Mount Zuch campaign into context, These actions by General Perišić did assist in the continued bombardment of Sarajevo, for which he's charged. I will wait for questions from the chamber, or I'll turn it over to Mr. Harmon.
Thank you, Madam Carter. Yes, Mr. Harmon.
Good morning again, Your Honors.
Good morning, Mr. Harmon.
Just need to change the volume on this. Yesterday evening and yesterday I reflected on the proceedings. I read the transcripts of the proceedings yesterday. And before I make my submissions on 7-3, there are 2 points from the transcript that I need to address and would like to address. The first deals with an answer that I gave Your Honor, Judge Malotto, which is found at 14661, where the question and where my answer was, the position we assert here is identical to the situation in your hypothetical situation. A few lines later, I said, I'm saying that the situation is identical in terms of the framework of our case. Now, the facts of the hypothetical were not identical and are not identical. What is the applicable legal principles are the same. In this case, and aiding and abetting does not differentiate, Your Honors, whether the substantial assistance to crimes is provided to armed forces or whether they're national or international. So my statement in respect of being identical dealt with the legal framework with which to apply the law as to any given factual situation. Now, Your Honor, the other point...
Before you move to the next point,
yes.
Let me just remind you that one, that was not a hypothetical case, it's a practical case. Secondly, that in fact it was given as an analogy. The underlying question that I put to you has not been answered, and I don't know whether you do intend to answer it. My question to you was, what is your authority for the proposition that a commander is guilty of aiding and abetting the crimes of his subordinates merely for the fact that he gave them arms and ammunition, paid their salaries, sent them to war, and while they were at war, committed crimes?
Your Honor?
And you can also, I'm asking for authority from the tribunal's jurisprudence and case law.
Well, Your Honor, I don't have case law at my fingertips. What I do have is the law that says that aiding and abetting, first of all, there is no case like this case in the tribunal. Okay? This case is unique on its facts, and this case will make case law. So I can't give you authority, Your Honors, to your question, Your Honor. There is authority.
Thank you.
Okay.
That was the question I asked.
Fine. Thank you very much, Your Honor. Now, the second point that we started out yesterday's proceedings, Your Honor, with a question that you posed on cumulative charging, 7-1 and 7-3. The question was not answered, I know, to your satisfaction. So I have asked Ms. McKenna to make a submission on this point, and then I will, after she makes that submission, I will then proceed, Your Honors, with 7-3 submissions.
Thank you. Madam McKenna.
Thank you, Your Honor. as Mr. Harman said, I'm going to make just a very brief submission on the issue of cumulative charging to provide a little more detail on the prosecution's position on this issue. In the prosecution's submission, liability under Article 7.1 and Article 7.3 are not mutually exclusive. The Blaskic appeals judgment at paragraph 91 provides that the provisions of Article 7.1 and Article 7.3 connote distinct categories of criminal responsibility. And so where both categories or where both modes are charged in the same case, each mode of liability reflects a different aspect of an accused's alleged criminality. And so with specific reference to this case, Your Honour, aiding and abetting is a form of accessory liability, and it requires a principal perpetrator who carries out the crime. And the OTP submits that Perišić is liable for aiding and abetting the principal perpetrators of the crime, but that Perišić himself is not the principal perpetrator. Rather, his liability rests on his aid or his provision of positive acts of assistance to the crime. And under Article 7.3, Perišić is charged with liability for his failure to prevent or punish the acts of his subordinates. And this legal characterisation would be best if the trial chamber feels that Perišić's criminal conduct is best or better categorised as a failure to act in respect of his subordinates when he was under a duty to do so. So, on the facts of the present case, the prosecution submits that Perišić is liable under both Article 7.1 and Article 7.3. However, as you recognised yesterday, the case law of the tribunal accepts that it's illogical to find an accused liable for failing to prevent and punish the very acts that he aided and abetted, and therefore the trial chambers usually decide where they find that both convictions could be entered. They enter the one that is more direct, that is Article 7.1. Yes, Your Honour.
Well, I just note that you probably moved slightly away from the question I put. You're talking of cumulative charges in the same case. I asked for cumulative charges that are mutually exclusive for the same conduct. But you may sit down. I just wanted to remember that that was my question.
Thank you, Your Honour.
You're welcome. Yes, Mr. Harman.
The first point I would like to address, Your Honor, is the issue of whether the regulations on the applicability of international laws of war on the armed forces was applicable to General Perišić. You will recall that the regulations were discussed by Mr. Starčević. There's a discussion on the regulations in our our final brief at paragraph 717 and 7 to 720. The exhibit is P2304. Now, a violation of those regulations could constitute a violation of military discipline, of which Perišić was required to enforce. The defense position on the applicability of the regulations is found in the defense brief, paragraphs 975 to 979. The defense asserts that the regulations did not impose an obligation on General Perišić because, one, Mr. Starčević testified that those provisions applied only in cases of armed conflicts of an international nature, and two, during the period of the indictment, there was no international armed conflict. Our position is those regulations did apply to General Perišić, and they did impose obligations on him. We say that because Mr. Starčević, shortly after he explained to your honors that the provisions applied only in a conflict of an international nature, it went on to say that because the offenses were so grievous and so terrible, the parties in the SFRY, in the conflict, signed a special memorandum committing themselves to apply all the rules that would otherwise be applicable only in an international armed conflict. You can find Mr. Starchevich's testimony at page 6976 through 6977. Now, on the basis of those regulations, the VJ General Staff issued two orders requiring adherence to the provisions of international humanitarian law. Now, there was a transition between the SFRY and the FRY. The P198, which is a newspaper report relating to the declaration of the new Federal Republic of Yugoslavia Constitution, on that date, the FRY issued a declaration in which they said, and I quote, "The FRY shall adhere strictly to all obligations which the FRY undertook in the past on the international stage." Moreover, Your Honor, P1183, the Federal Republic of Yugoslavia Law on Defense, Article 19, states, "Members of the armed forces of Yugoslavia taking part in armed combat shall, under all circumstances, adhere to the rules of international laws of war and other rules," and it carries on. So our submission is, Your Honor, that the regulations on the applicability of the international laws of war in armed conflict situations did, in fact, impose an obligation on General Perišić. Those obligations continued after the SFRY became the FRY. Now I'd like to turn to 7.3, Your Honors. In respect of 7.3, there are three elements to the offense. The first is there must be a superior-subordinate relationship established. The second, the superior knew or had reason to know that his subordinate was about to commit or had committed the underlying crime. And three, the superior failed to take reasonable and necessary measures to prevent the subordinate from committing the crime or to punish the subordinate for having done so. I'm not going to address the second and third elements. We have addressed the knowledge element of 7.3 extensively in our brief. That's found at paragraphs 563 to 683. The defense concedes that General Perišić failed to punish his subordinates. You can find that in the defense pretrial brief, paragraph 135, subpart V. And they take the position that he did not have effective control and therefore he could not have prevented his subordinates from having committed crimes. What I want to focus on is the issue of superior-subordinate relationship and the existence of a superior-subordinate relationship. Now, the test of whether a superior-subordinate relationship exists is whether there is effective control, which means whether there's a material ability of the superior to prevent or punish the subordinate from having perpetrated offenses. It's a fact-based determination. It is not. It is a fact-based determination. Your honors have to take a look at the evidence in this particular case, and the parties have defined for the court in their briefs what are the indicators of effective control. You can find in our brief at paragraph 697 and in the defense brief paragraph 75. But those indicators that we cite are not the only indicators. They're a range of possibilities, and they include the position held by the superior, the capacity to issue orders, the nature of the orders which the superior had the capacity to issue, whether his orders were actually followed, the power to take disciplinary action, the authority to promote officers, and the authority to remove officers. Our position is, Your Honor, that Personnel Center members serving in the VJ personnel serving in the Personnel Center members were VJ officers, and as such, Perišić had effective control over them. The defense position, which is found at paragraph 207 of its brief, is that the VJ officers serving in the VRS and the SVK were members of those armies and not of the VJ. So that's where we part company. I'd like to take a look at the evidence, Your Honor, that supports our position. First of all, let me take a look at the evidence that shows there was the jury authority over personnel serving in the personnel centers. First, Perišić was, of course, the highest-ranking officer in the VJ. He was superior to all other officers. Two, the personnel center formations, if we could have the personnel center formations, as you can see on the screen before you, were part of the VJ general staff. They were under the sector on manning, mobilization, and systematic issues under the personnel administration. So they were part of the VJ general staff. Three, Mr. Starchevich testified that persons who were assigned to the 30th and 40th personnel centers were VJ members according to the law. You can find that testimony at page 5489, lines 12 to 15. And as a matter of law, Perišić had authority over VJ personnel. Now, in addition, Your Honor, there was considerable litigation in the Fry relating to the status of persons serving in the personnel centers. The first litigation I'd like to refer to, and by the way, you can find that discussion in our brief at paragraphs 789 to 792. The first case I'd like to discuss with Your Honors was the case of Colonel Blagojevich. Colonel Blagojevich was somebody this tribunal is familiar with. He was convicted for his participation in crimes in Srebrenica. But prior to coming to The Hague, he sought compensation for unused annual leave. His request for compensation was denied by the 30th Personnel Center, and he appealed. He appealed, claiming that he took part in armed operations in Bosnia on the basis of orders he received from his superior, and that he was a member of the VJ. The Supreme Military Court agreed with Mr. Blagojevich. They stated in the judgment, and it's in front of Your Honors, it is not contentious that Blagojevich was outside the VJ during the period for which he is seeking compensation, i.e., as a VJ member, he was part of the former, he was in a part of the former SFRY territory on the orders of a superior officer, and he did not take his annual leave for the years that are indicated. So the court in the Blagojevich case held that he was a professional VJ soldier. VJ law applied to his request for compensation, and they granted his request. The second case involves Dragomir Milosevic, who, as you know, was convicted in this tribunal for crimes committed in Sarajevo. General Milosevic brought a claim, I should say, for compensation for wounds that he received in combat in Sarajevo. The Fry challenged his claim. They asserted that he was performing duties on behalf of the VRS and as part of its military. the court rejected the Fry's position. The court said, and on the monitor before you, it was established beyond a reasonable doubt that the plaintiff was a professional soldier of the VJ at the time of his wounding and was on its payroll at that time. There's another judgment I won't go into in detail. Your Honors can find it. It's Prosecution Exhibit 872. It holds essentially the same thing. It is a claim by Dragomir Milosevic for family separation allowance. Now, the judgments of the Supreme Military Court were followed in decisions by the 30th Personnel Center. So when a claimant subsequently went before the administrative body to make a claim, he was granted compensation. If we could take a look at the claim in the decision, the administrative decision by General Mladic for unused annual leave, that is Prosecution Exhibit 1919, and you will see that on the monitor in front of you that there's a finding that General Mladic was serving in military post 3001, which we know is the military post for the 30th Personnel Center. And they go on to say that in accordance with the position of the Supreme Military Court in Belgrade, that the law was violated, given that it is undisputable that the above mentioned did not receive the fixed salaries for the duration of the period in question, and was serving, that is, working in the Yugoslav army. The above mentioned is entitled to a salary pursuant to the cited provisions of the law. So it is our submission, Your Honor, that as a matter of law, persons serving in the VJ personnel centers were VJ members. But that doesn't conclude the inquiry that's required of Your Honors in assessing whether or not General Perišić had effective control over members of the personnel centers. It's only some evidence that he had effective control. You have to look, Your Honor, at other factors which we, both parties, have identified as factors indicative of effective control. I would like to go through some of those with you. The first is that the salaries and benefits for persons in the personnel centers were paid by the Federal Republic of Yugoslavia. They were not paid by the Republic of Srpska. They were not paid by the Republic of Serbian Krajina. Those entities paid salaries and benefits to their soldiers, not to VJ soldiers. Another indicator of effective control is whether or not General Perišić had the capacity to promote his subordinates serving in the personnel centers. The defense argues in its defense brief, paragraphs 414 et sec, that promotions in the VRS were made final in the VRS, and that the only steps taken in the VJ were to verify those promotions to protect the status rights of an officer. Now, we certainly accept part of that proposition. There were promotions within the VRS and the SVK. However, the process of verification, as it's referred to, was not merely to protect status rights. The process of verification was whether a determination of whether or not the person who was serving in the VRS or the SVK merited a promotion in the VJ. In other words, promotions were discretionary. They were not automatic. Now, there are two types of promotions that occurred in the VJ. There were regular promotions and there were extraordinary or exceptional promotions. It depended